Betty.
Judge.
Okay, it's 11 o'clock. Are there still people trying to link in?
We are waiting for a few, but it's a tight schedule, so I think we should start, Judge Hussain.
Yeah, look, I can, in the meantime, just introduce the whole program.
I think so.
And by then, the others can catch up. As I see, there's quite a few missing, eh?
Yes, there is.
Yeah. Okay. All right. Good morning, everyone. I hope everyone can hear me clearly and can see the screen. I'll be using a PowerPoint presentation with my own presentation, and I'd like to welcome all of you to the course. We're going to run it for 3 hours today and then 3 hours tomorrow. To concentrate on a screen for more than 3 hours is just very difficult. So that is why we decided to split it over 2 days. And we've done this with a number of other webinars, and it works pretty well. There will be time at the end of today. That would be, would that be around 2:30, Betty?
We'll go up until 2:30, and from 1:30, and from 1:30 to 2, we'll have questions.
So I've got to go until 1:30.
Yes.
And then from 1:30 to 2, there can be questions.
That's correct.
Okay. And we'll take a break at 12:30, okay? Comfort break. Okay.
Yes.
Let me start off by telling you what to expect in this course. It's about evidence. Now, all of us studied evidence at university, the law of evidence, as it was called. And I haven't met anyone who actually learned anything in that course. I mean, of course, we wrote it and passed it. We swatted off all these various rules and so on. But when you get into practice, then you realize that the whole thing was useless. Now, my approach here is very different. It's about what you do as lawyers, and it is how you apply the rules of evidence in your practice. Now, if you are engaged in any kind of dispute resolution, whether it's trial work in the magistrate's court or the high court or any of the other courts, or it's a motion matter or an appeal, or it's arbitration or mediation, you have to have a practical understanding of evidence. It's what I'm going to try and do here is take you away from the academic approach and give you what I called an applied approach. So you will be able to apply the rules of evidence to the work you are actually doing. I'll take you through this from the point of taking instructions all the way into a trial. And I can assure you that the techniques that I'm going to explain to you are tried and tested, and they work. There's nothing academic about it. As litigating lawyers, the facts are the most important component of your work. Now, the word evidence is what we bandied about at university. We called it And even now, we go to court, we'll say, leave the evidence, or what, there's no evidence, or is there evidence, and so on. You know, evidence simply means one thing. It means the facts. And how we present those facts to a court, to an arbitrator, is governed by a set of rules. As far as evidence is concerned, the rules can be found in the common law and in statute. Now, the emphasis here is what to do in order to make your client's version more persuasive. Now, let's get one thing straight. What do we do as lawyers when we litigate? There's a dispute. There's a dispute of fact and there's a dispute of law. Now, the parties can't settle, so you need to go to court. We have pleadings that tell us what the issues are. We have pre-trial procedures dealing with documentary evidence and visual evidence, and I'll get to that in more detail. And the rules of evidence tell you how you can present it. But as a practitioner, there's more to it than that. Now, the rules of evidence are not complicated. They're easy to follow. What was never taught to you or to us, I put myself in there as well at university, was the academic side of the course. No one told you how to apply it. Now, when you take instructions, what that means is you obtain the facts. When you obtain the facts, your job as a lawyer is to work out what is your client's version and will it support a cause of action in law. That's the first thing you do as a lawyer. Once you've established that you do have the facts which can support a cause of action in law, then you can go to court. But the correct approach is not merely to say, well, do I have the facts that can support a cause of action in law? Now, initially, when you are after you took instructions, you will have to prepare your particulars of claim, or you will have to write a founding affidavit. Doing that is a far cry from what you have to do in court. Ultimately, for you to succeed, you have to convince a judge to accept your version of what happened. And that's what evidence is all about. It's not about the rules. It's about you having the ability to present your facts to a judge in such a manner that the judge will find it persuasive and accept your version rather than your opponent's version. That's what we want to do. So, at the heart of any trial or application or an appeal are the facts of your case. Now, this is the first mistake the academics make at university. Let's think about it. When you finished your LLB, you went into a law firm to serve articles, or you went to one of the bars to serve pupillage. I can assure you, everyone has the same experience. They arrive there at the office, and in the first week, you don't really do much. You get to start meeting people, and all the last year's candidate attorneys and the PAs will spend the week dumping all the rubbish files onto you, and you'll be very happy. By the time you get to the third week, you wonder if you're in the right profession, because you don't know what to do. everything is overwhelming. So you do what most people end up doing, and it's a mistake. You start looking for precedents for everything. If you have to write a simple letter to another firm, you look for a precedent. If you have to draft anything, a notice, particulars of claim, a plea, whatever it is, a notice of motion, you will want to look for a precedent. Well, the problem is, it's not that you don't know how to write. You can all write. You've got degrees. You can draft. What you don't know is what to do with the facts of your client's case. And it's quite astonishing that there are many lawyers out there who can start litigation without knowing much about their client's facts at all. Because the pleadings can be sent out on a precedent, so carries on. The real trouble starts when you get to trial, because then most people find that the pleadings don't match the facts. So you've all seen this happen in court. The matter gets postponed. Now, that's not a proper way to practice. As a lawyer, the facts are the most important, not the law. The law is the supporting act. The facts are the most important. If you have to make submissions of law, they are not convincing to a judge if it is not supported by the facts of the case. I mean, just to prove the point, when you tell a judge in court, my lord, may I refer to A versus B, 2001, volume 3, SA, SCA. Now, you're going to tell the judge that this judgment is binding on your lordship, and it's in favor of your case. Well, the first thing the judge will do is say, but hold on, what are the facts of this SCA decision? And can you distinguish it from the facts of this case? Now, the answer to those questions is yes, they can be distinguished on the facts. Well, the case is no longer binding. At best, it might be of some interest to the judge, but it is certainly not binding. So the facts are crucial. You can present the law in the most elegant way, but if the facts don't support it, you're going to lose. So that is what applied law is about. Now, we are not academic lawyers, we're practicing lawyers. So now we use the law to find solutions to our clients' problems. At university, we studied the law for the sake of finding out what the law is. So it's what a judge in England called it library law. It's library law. Now, we're not going to talk about library law here. We are talking about applied law, where you use the facts in court to resolve the dispute. And that's what this course is all about. Now, I'm going to tell you what is expected of a trial lawyer, and then I'm going to take you to what judges are doing. You need to understand what a judge is doing in court so that you can present your facts accordingly. And here's another gap in the education. I don't see any of the courses at university which tell the students, here's the law, but let me show you, let's go and look at how a judge applies it, how a judge resolves disputes. That never happens, but I'm going to show you now. As a trial lawyer, you must know how to present the facts in a trial in a manner that the judge finds persuasive. And in doing so, you have to comply with the rules of evidence. Now, the rules of evidence are not complex. They're easy to comply with. Where the problem happens is when the lawyers don't know how to manage their facts and then present it to the judge. But remember, it is not the rules that matter. It's the quality of the evidence. In other words, the quality of your facts. There's no point in spending your energies observing the rules of evidence and reading case law on evidence when your witnesses are rubbish. I mean, seriously, you're wasting your time. First, establish that you've got good witnesses that can present relevant, reliable, credible evidence to a judge. When you've got that, then you worry about the rules, okay? Now, before we go anywhere, you have to have an understanding of the adversarial system that we use in our courts. Those of you who go to court regularly, high court, where there's motions, trials, appeals, criminal courts, civil courts, the same in the magistrate's court, you will encounter what we call the adversarial system of dispute resolution. There are other systems. The other one you would have heard of is called the inquisitorial system. Now, the adversarial system is used throughout the Commonwealth countries, as well as the United States. The inquisitorial system is used in many countries. The European Union, for example, use it. Many of the Southeast Asian countries and the Middle Eastern countries, they use the inquisitorial system. So what's the difference? In an adversarial system, the judge is a neutral trier of fact. The judge does not investigate the case. So the judge can only make a finding based on what the parties present in court. Now, do you see how important the role of the lawyer becomes? Because the judge can see something's going wrong, or the judge can see an enormous gap in the evidence, but the judge can't do much about it. The lawyers have to present. And if the lawyer who bears the onus leaves a gap in the evidence, the judge will say, look, you didn't discharge the onus. I'm going to find against you, and that's the end of the matter. The inquisitorial judge investigates the facts. They take an active role. They call witnesses, they interrogate witnesses, they look for documents, they will read documents. They are looking for the truth. Whereas the adversarial judge is not looking for the truth. How can he? The judge wasn't there. He doesn't know, or she doesn't know what happened, and does not have the powers to go and investigate. So, in our courts, the judge will find in favor of that party who presented the facts in a manner that persuaded the judge to accept it. So when an adversarial judge says, I find that Mr. Mokoena, the witness, was impressive, and I accept that he's telling the truth. Well, what happens when a judge says that? Well, it's quite simple. The judge cannot say what Mr. Mokoena said is the truth. No judge can say that. What a judge is actually saying is that based on his evidence, I am satisfied, or I am persuaded that for purposes of this hearing, he was telling the truth. It doesn't have to be the truth. Do you get it? That's what happens in our courts. Whereas the inquisitorial court, the judge actually interrogates the witness, looks at the matter, investigates the case. For example, in France, where they use the inquisitorial system, you will not read in the newspapers that a judge is hearing a case. What you will read is that the judge is investigating the case. Here, the judge hears the case and is confined to what the parties present. So if the quality of what you present is bad, then you're going to lose. Simple as that. Okay. So you see how crucial it is for you to prepare the evidence and be able to present it in such a manner that the judge listens to it and says, ah, that I can accept. I'm impressed with that version. Okay. So with a neutral trier of fact, there is little or no scope for the judge to go beyond. Now let's look at what the judges do. It's very important for you to know what a judge is looking for, what the judge expects from the lawyers. Okay. The most important thing for a judge, now you know that when you go to trial, the judge will read the papers. The judge will read the particulars of claim and the plea. Now I can assure you, in this country, even now, with case management, the pleadings are quite useless because they are mostly precedent-based and have very little to do with the version, and it's like going through the motions. Pleadings are very badly drafted in this country. It's the same with affidavits. It's because the approach to the facts is all wrong. It is not your job to quickly issue a summons by grabbing a precedent and copying and pasting and sending it off to the registrar's office. I mean, any idiot can do that. You're not a lawyer, okay? The judge will look at the facts. If the pleadings and affidavits are unhelpful, you must be ready to tell the judge what happened. In other words, what happened that caused the parties to become involved in a dispute to the point where they cannot resolve it without the assistance of a judge. You will have to tell your client's story, and you will also need to know it's an adversarial court. You'll have an adversary, the other side, the defendant, and you'll need to know how to undermine the defendant's version. I'm going to show you how you do that. So a judge is faced with a set of historical facts. And in this country, historical is the right word for it, because it could take anything up to 6 years to get to a trial. So now the facts are 6 or 7 years old, and now you want to present it to a judge. So what the judge does is, historical facts also means that the judge knows nothing about the matter. All the judge is going to hear is a story about what happened 6 years ago. Each party, plaintiff and defendant, presents a version of what actually happens. Now, this might sound a bit ridiculous, but this is actually what happens. Plaintiff presents its version of what actually happened. The defendant presents its version of what actually happened. So you've got two versions of what actually happened. Now, do you realize this sounds a bit ridiculous? Because in truth, only one of those versions actually happened. But a judge now has to resolve this by making a choice between opposing versions. How does a judge do this? The judge will consider the evidence available. In other words, will evaluate the evidence. For instance, the judge will make a finding on credibility of a particular witness, and then the judge will evaluate the evidence in the light of who carries the burden of proof, according to the burden and standard of proof. Burden of proof means who bears the onus. Usually it's the plaintiff. Standard of proof, there are two standards. The one is on a balance of probabilities, and I'm going to explain that to you in detail, and how the evidence will assist you to discharge that onus. And of course, in the criminal cases, you have proof beyond reasonable doubt. So the judge is constrained by the facts presented according to the rules of evidence. So the judge is not investigating. The judge will apply the rules of evidence. For example, you lead a witness, and the judge says to the witness, "How do you know that?" And the witness says, "Well, my friend George saw the whole thing and told me about it." So now the judge knows immediately that's inadmissible. It's hearsay. Unless George is going to be called, this witness's evidence must be discarded. It's of no help. The judge makes a note of the undisputed facts that emerge from the evidence. Now, let me pause there for a moment. As trial lawyers, we tend to concentrate on the disputes of fact between the parties, and there's nothing wrong with that. But there's something else that you must consider. That is the undisputed facts between the parties. So why are the undisputed facts so important? Well, to start off with, in every dispute that requires to go to court, there must be, between the parties, a set of undisputed facts. You will never have a case where everything is disputed. There are no undisputed facts between the parties. The parties cannot make any admissions of fact. There's no such case, simply because disputes are caused when parties get together, or they do something that brings them together, like signing a contract, committing an assault, driving negligently into another car. All of those things cause people to get together. When that happens, there is always a set of undisputed facts. In other words, disputes do not happen in a vacuum. Disputes are between people and what people have done to one another, how they got involved, and that's what trials are about. Trials are not about the law. Trials are about people and their facts, people and what they've been doing. Now the judge has to resolve this fact, the dispute. Now, what is so important about the undisputed facts? Remember, a judge listens to a witness. The judge doesn't know if that witness is truthful or not, because the judge doesn't have divine powers where they can say, "Oh, this person is telling the truth," or "that one's telling lies." Judges can't do that. Judges are humans like us, they're lawyers. So how do they deal with it? One of the most important tools in a judge's in a judge's method of resolving disputes is this thing called the probabilities. Now let's go back to the civil standard. What's the civil standard? Proof on a balance of probabilities. The standard is not truth. The standard is probabilities. What does that mean? It means that for a judge to accept a version, the judge does not have to find that it is true. The judge only has to find that it is probable. In other words, it is likely to have happened. Now, here's a piece of advice. If you go to court with a version that is not likely to have happened, or a version that the judge is not going to be persuaded that it is probable, you are going to lose. Just take it from me, you will lose. Okay? Now, it's a bad lawyer who listens to his client's version and is unable to work out that this is a version that that is likely to have happened, so much so that a judge will accept it. Now, as lawyers, you need to cultivate the ability to hear a version from your client or from a witness and work out if that is likely to have happened. If it is not likely to have happened, don't go to court. Use Rule 41A, settle it. There's another problem that faces lawyers every day, and you've all come across it, where your client tells you a version and you immediately realize, this is nonsense. You know, I mean, I don't believe it. But now you're sitting across the table from your client. You can't say to your client, hey, listen, Mr. Smith, I think you're talking rubbish. You're a liar. And I'm not going to listen to this. Well, Mr. Smith will be very upset with you. He will go to another law firm and he'll tell everyone you're a rubbish lawyer. There's another way to deal with it. When your client gives you a version that is improbable, tell the client, say, listen, I don't think a judge will find that version to be probable. Now, let me explain. Now explain why a judge might find that that version is not likely to have happened. Now, that's a nicer way to deal with it than to say to your client, hey, listen, you're a bloody liar, okay? Remember, the client's paying you a fee. So now, how do you work out if the version is probable? Now, obviously, if someone gives you a version that's bizarre or that's quite obviously nonsense, that's easy. You can say, no, the judge is not going to accept that. You're going to lose. What happens if the version is quite subtle? And it's not immediately or obviously so that it is that one can't believe it. It's not obvious. How do you work it out then? This is what you do. First gather all the facts. Now, here's a mistake that many lawyers make. They don't get all the facts before issuing the summons. That's fatal. Now, take it from me, people. Do not send out particulars of claim if you don't have all the facts. By all the facts, I mean you must have all the documents your client has. You must have interviewed all the witnesses. Now, it's only in a rare occasion where you're facing a time bar or any other form of prescription where you don't have time. Well, do your best. You'll have to work through the night. Now, remember, if you have a poor knowledge of the facts and you send out particulars of claim, if the cause of action is wrong, and if the material facts were not pleaded, it does not interrupt prescription. You are going to lose anyway. So take the time and get all the facts. Now, how do you work out the probabilities? Write down in a file or what you see as all the undisputed facts. Undisputed facts also includes those facts which you know your opponent will not be able to dispute. Even if they file a plea that says allegations are denied, don't worry about it. There's no basis for the dispute, put it in the undisputed column. Now test it. Now take the disputed part of the version and ask yourself, do the undisputed facts support it? If the undisputed facts don't support that version, it means that a judge will not find it to be probable or likely to have happened. I'm going to give you a simple example, just so that you can understand it. You're all familiar with accident cases, okay? So your client tells you that there was an accident in a robot-controlled intersection. So he tells you that the robot was green for him, and the other driver, the defendant, was coming across the intersection and failed to stop at the red robot. Now, the defendant's version, he tells his lawyer, look here, I was driving towards that intersection and the light was green for me. And as I entered the intersection, the other car slammed into me. Now, immediately as lawyers, you know that both versions cannot be right, because it is highly unlikely, improbable, that at the point when the impact took place, the robot was green for both drivers. One of them is lying. Do you see? On the probabilities, it was red for one of them. Couldn't have been green for both of them. But now let's think about the possibility. Of course, it's possible that the light was green on both sides. Why is it possible? Because the robots could be malfunctioning. So it's possible, but that's not the test. It's not what the judge will ask. Unless someone makes out a case that the robots were not working on that day or were faulty, a judge will say there's no likelihood that both drivers were seeing green when they entered the intersection. One of them is lying. Now, let's take it a step further, just to illustrate this. After the accident, the police arrived and they prepared a police report, which was discovered, and you've got it. Now, the police report indicates that your client left a skid mark of 25 meters before the point of collision. It's not disputed that such a skid mark was there. The police took a photograph and measured it and put it in the report. Your client, of course, tells you it's not his fault, this accident. It's the other party. Now, the obvious question that you will ask is, what speed were you going? Your client, like all good drivers, will tell you he was doing 60. Okay, he's doing 60. Now, client tells you he's doing 60. Now, let's test that version against the undisputed facts. What are the undisputed facts? It was a dry, sunny day. The surface is a tarmac. The speed limit is 60. Okay. There is a skid mark of 25 meters left by your client. Now, ask yourself, do those undisputed facts support your client's version that he was driving at 60? Of course it doesn't. Because if he was doing 60, number one, he would have stopped in time. There would have been no collision. Number two, if he was doing 60 and he applied brakes, he was not going to leave a skid mark of 25 meters. The undisputed facts tell you that your client was speeding. Do you see how it works? That's exactly how a judge sees it. Now, if you go to court and you know there's an undisputed fact that your client left a skid mark of 25 meters, you're not going to convince a judge that your client was not speeding. If your client insists on saying, no, I was doing 60, and you must know by the time when your client is being cross-examined, he'll start doing even less. Okay? By the time cross-examination finishes, your client will be doing 20 k's an hour. That's exactly how witnesses behave. Well, your client's going to be disbelieved. You're going to lose the case. So this is how a judge deals with it. The judge will, after considering the evidence, will decide which version is more probable. Obviously, if a judge discredits a party's witnesses, then the version goes out with the witness. The witness is unsatisfactory, cannot be believed, the version is out. So there's no question about whether or not the version was probable or improbable. The judge just rejects it. But what happens when the witnesses are equally impressive on both sides? What then? What a judge does is looks at the disputed part of the evidence. What is the issue? And now looks at each party's version in respect of that issue. And then the judge says, let me look at the undisputed facts and ask myself, whose version does it support? Do the undisputed facts support the plaintiff or does it support the defendant? And that's how the judge will separate the parties and say, I find that defendant's version is the more probable and I accept that version and I'm persuaded that it is the truth. That is what happens. Now, when a judge is persuaded to accept a version, the judge will show that her reasoning and conclusions of fact and law are practical, number one, suit the facts as found, and will provide an effective and workable remedy to the winner. Now, right there is what a judge is supposed to do. A judge is supposed to hear the story, evaluate the facts, find a suitable solution, and give an order that amounts to a workable remedy to the winner. A judge will only make an order that is supported by the facts and the law. Now remember, the law doesn't feature until the judge makes a finding of fact. The judge, you can only apply the law as counsel or as an attorney when there is a finding of fact. Now, you will tell the judge in argument to accept your client's version and that version is supported by the law. The judge, of course, will evaluate this. If the judge finds that your client's version or any aspect of the material dispute is improbable, not supported by the facts, you will lose. You would have failed to discharge the onus. So your job is to assist the judge to accept your client's version of the disputed facts. That's your job. Everything you do as a trial lawyer is focused on that. This business of entering appearance to buy time and proceeding with a rubbish version on the basis that those are my instructions, well, forget it. That doesn't happen anymore, okay? I'll come back to that issue around how lawyers deal with this in a moment. And this whole object of presenting your client's version of the facts in a manner that is persuasive begins with good drafting. Most people don't realize this. That is why I say, obtain the evidence first. Get all the facts first. Only then do you draft. Now, when you obtain the facts, your job is to consider all the facts. And as a lawyer, before you apply the law, forget about the law. Ask yourself one question. Is this version likely to have happened? Is it probable? Okay. Is it plausible? And now, if you are not convinced as a lawyer, there's no chance that you're going to persuade a judge. Trust me, if you don't buy your client's version, you will not sell it to a judge. When you draft pleadings and affidavits, you must plead your peculiar facts of your client's version. Do not plead from precedents. There's the problem. Because once you use the precedent slavishly, of course you can issue the summons, it will be fine, no one takes exception, your opponent will plead a bare denial, and you and your opponent are very happy and you get to trial. Then the trouble starts. Okay, because when the first witness takes the stand, the judge will be wondering, but what's he talking about? It's not relevant to the pleadings. You will be in serious trouble. Now remember, when you plead good facts and you present a persuasive version, you are in a position to write excellent heads of argument. Because the facts will support your version, and the facts and the law will, your facts will support the applicable law. You will be able to discharge the onus. When your facts are bad, it's impossible to write heads of argument. I mean, some of you may have experienced it. You're reading this record and it's just full of nonsense. You can't see where your client has a viable version. What do you put in the heads? Okay. And whatever you do put in the heads will be of no assistance. So, as a trial lawyer, you must understand that the judge must be persuaded by the evidence you present, by the facts of your client. Your job is to present the judge with a persuasive story. Now, what makes a story persuasive? There are three things you must understand, and it forms part of the golden rule of evidence. The three things are, firstly, the evidence must be relevant to an issue. In other words, the evidence must be useful or help the judge to resolve the dispute. If it is not helpful, we say the evidence is irrelevant, don't bother to lead it. That's the first rule, must be relevant. The second rule is relevance is not enough. it must be admissible in its form. You're all familiar with this, with the admissibility of evidence. What it means is that you present, a witness takes the stand and presents a version. That version must be presented in a manner that is admissible. In other words, it must not fall foul of a rule of evidence. So, for example, you call a witness to testify that the defendant drove through a red robot. So you call Mr. Jones. Mr. Jones tells the judge, my lord, it is the defendant who drove through a red robot. Now, that's obviously relevant. There's no question it's relevant because that's the issue. And that the evidence that the defendant went through a red robot will be of assistance to the judge to resolve the issue. But now the judge says to Mr. Jones, how do you know that defendant went through a red robot? Oh, my lord, my friend George saw the whole thing and told me about it the very next day when I met him. Okay, so now it's hearsay. The value of that evidence as weight, as proof of a fact, depends on someone who is not testifying in court. So unless you are going to call George to give that evidence, Jones's evidence is inadmissible. So now we got two requirements for the story to be persuasive. Two requirements. Must be relevant and must be admissible. Now, right there, most of you will remember from university is the golden rule of evidence. So what is the golden rule of evidence? The golden rule of evidence goes like this. All relevant evidence is admissible unless excluded by a rule. Remember that? Now that's what it means. Must be relevant to an issue, must be of assistance, and must be admissible in its form. Okay? If a witness gives evidence and it amounts to lay opinion, we know that's not admissible. So there's no point in calling it. Okay? So it's quite the golden rule of evidence is something you swatted, but now you understand what it means. But there's a third rule, which they don't tell you about at university. And that's because the lecturers have never run a trial. The third rule is that the version that you present must be probable. If it is improbable, a judge will reject it. It must be a version that is likely to have happened. Then the judge will say, I find that on the probabilities, that version is likely to have happened. I find in favor of the plaintiff. Now do you see what is meant by proof on a balance of probabilities? Now here's the trick. These three requirements, relevant, admissible, probable, test your version against those three requirements. If your client's version fails any one of those three tests, you lose. It's not enough to be able to satisfy two and not one. It must be 3 out of 3. If you're not getting 3 out of 3, don't go to court. That's the formula. Okay. The story must be told by witnesses who have personal knowledge of what actually happened. Now, you've heard this thing called the best evidence. The best evidence is the evidence of a witness who has personal knowledge. And we all know that kind of witness as an eyewitness. That version must account for the undisputed facts, which undisputed facts must support the version tendered by the witness. That is the first test that the judge applies. The judge doesn't say, is that true? That's not what the judge is thinking, because he'll never know that. The judge is asking, is that probable? And how will I measure that? Is it supported by the undisputed facts? Yes, it is. Okay. And Mr. Smith was really an impressive witness. I'm convinced that I'm persuaded that he's telling the truth. So the version must be presented by a credible witness. Okay. Now, all of you have heard lawyers, though especially ones who lost the case. They come out of court and they do two things. One, they lost because the judge was an idiot. You've all heard that one before. Or, number two, we lost because I was dropped by the witnesses. You heard that phrase, dropped by the witness. In other words, the witness performed badly, the judge disbelieved the witness. Well, the fault is not with the witness. The fault is with the lawyer. The lawyer did not consider the version carefully enough, did not prepare the witness carefully enough, and did not lead the evidence correctly. Now I'll deal with that later. So the judge finds against you. That's the adversarial court. The version must be supported by relevant detail. So when you get a version, remember, client or witness must be able to support this with details. Things like time, date, weather conditions, who was present, what were the circumstances. All of those things must support that version. So the version must be probable in relation to the circumstances of the case. Always remember, for a version to be persuasive, you must present it in a chronological sequence. Now, that is very important. Why? Because chronology is what glues the version together. It's chronology that helps the judge to make sense of this version. Now, you've all listened to witnesses, or you've heard people, you've consulted with people who give you a story, and it's all over the place. They started in the morning with something, and then it moved to the next day, and then it came back to the previous evening, and it's a complete mess. It's a version, but you cannot present it like that to a judge. You have to tell the witness, let's start again with your story. But now we're going to go through it step by step from beginning to end. And when you do that, the first thing that you'll work out is whether or not this version is likely to have happened. Because if the version does not make sense sequentially, then it is going to be improbable. Sequence is what makes sense to the judge. And you'll be surprised how many lawyers don't sequence the evidence. Now, I'm giving you a practical tip, and never forget to use it. For every witness that you call, starting with client and the supporting witnesses, doesn't matter how many you have, listen to the version. apply the test. Is this relevant? Is it admissible? Is it probable? If you say you got a yes for all three, it's like these competitions. You must get 3 yeses. Okay. If you don't get 3 yeses, you're out. Okay. Now just remember that. So if you don't get 3 yeses, then there's something wrong with the version. Don't even try to present it in court. Tell the witness, please go. Thank you very much. Don't call us, we'll call you. Okay. Now, those are the 3 things that you have to do. Now, in order to satisfy those 3 requirements, especially the third one being it must be probable, you must sequence. You have to sequence the facts or the evidence. Now, what you do is you take each witness and you have to write down the statement in a chronological sequence, strictly. If you have documentation, the documents must be sequenced before you review them, okay? The oldest document on the top, the latest one at the bottom. You must sequence. When you satisfied the test and you got 3 yeses, now open up a file and prepare what is called a chronology document. What is a chronology document? It's a document that states, just in a 1 line, okay, those of you who haven't drafted chronology documents, they're very easy. 3 columns. Left-hand column is a narrow column. It's merely meant for referencing, 1, 2, 3. The middle column is the widest column, where you describe an incident or a transaction. And the third column has a date or time or both. And you now write down only the material facts of the version. Leave out the details. No facta probantia, just the facta probanda. That's the material facts that you need to prove your cause of action. Write that down in a sequence. Now, if you, just to illustrate how important sequencing is, in the opposed motion court here in Gauteng, in the SCA, in the Constitutional Court, you are expected to file a chronology document with your heads of argument. Why? Because judges know that if you do not sequence the facts, they, as judges, can be misguided. Okay? So you could have an injustice taking place. Now, get into the habit as lawyers. Whenever you're dealing with facts, please sequence the story. Never forget that. Now, the version or the material facts must contain all the elements of a legally recognizable cause of action. Now, this is where it goes wrong for many lawyers. And it's because when they issue summons, their particulars of claim or a founding affidavit comes out of a precedent. They don't know all the facts of their case. They did not say, let me look at the material facts. And it's simple. Get the material facts. Apply the test. If you don't get 3 yeses, tell your client to settle. If you get 3 yeses, now look at it sequentially. Okay, sequence the thing. Only then do you say, well, if these are my material facts, what does the law say I'm entitled to if I can prove those facts? Okay. So you look at those facts and you say, look, this case looks like it falls under the law of contract. It's a contractual dispute. So now let me look at the law of contract. What does the law say is my remedy if I can prove these facts? So the law will tell you, if you want this remedy, you want damages or you want to enforce the contract, the law will tell you what are your requirements. Those are what we call the elements of the cause of action. But if you merely plead those elements, and this is a mistake many people make when they use a precedent or they use AMBLA. You know, just get one thing straight. AMBLA is not a precedent. AMBLA is very useful for telling you what the law says are the material facts. What you have to plead is your version that satisfies those material elements or facts. Now you're pleading or drafting like a lawyer. I explained this in my book on drafting skills. If you don't have it, get it. It tells you exactly how to do this. The story must come across clearly, logically, and must be probable. Any version that appears to be improbable or contains elements of fact which the judge might find to be implausible is not likely to be persuasive, and your client will not be successful in discharging the onus. And I'm going to show you in more detail how you do this. Remember to keep the evidence and your submissions relevant to the issues at hand. When you're making submissions, always keep them relevant to the issue. Now remember, you are in court because there is an issue or issues which require a trial to resolve it. You know from case management that lawyers are supposed to have case conferences and agree on what the triable issue is. Now, I can assure you, we do that in case management only because the pleadings don't tell you, because they come out of a precedent. You can't work out what the issue is. Okay? And when you're preparing your facts, it is very important when you're presenting evidence to make use of what I call visual evidence or exhibits. The reason why visual evidence works is because it is seriously persuasive. You know that old cliche, a picture paints 1,000 words. Okay? It's true. I've been in trials where the lawyers will lead a witness about an incident that took place somewhere. Let's say this witness is describing how a bridge collapsed. It's an engineering dispute. And now the judge is sitting there and listening to this witness. Has no idea what happened. He's never been there. Okay? But if a smart lawyer presented the judge with visual evidence, for example, aerial photographs of the site where the bridge is, the judge can see straight away where this bridge is. Photographs of the bridge after it collapsed. A model of a similar bridge is brought into court, and an expert explains where the stresses were and how this bridge collapsed. The judge sees it. Visual evidence. Visual evidence is extremely persuasive. Do not miss an opportunity to use it. These days, with digital technology, the scope for finding visual evidence is limitless. Okay? You know, when I was a young advocate, an attorney, to get a visual photograph was a most expensive undertaking. Okay? You have to get a cameraman into a helicopter. It's going to fly up, cost you thousands for every minute that thing is up in the air. They take the photographs, and then they come back and land. You have to wait 2 weeks for the photographs to be developed and so on. These days, it's instant. You go onto Google Earth, and you can zoom in on the scene, download the pictures, and there, it's done. Persuasive stuff. Things like CCTV camera footage. CCTV cameras are everywhere. And video footage taken onto cell phones. People take videos of everything that they see. You can use those things in court. It's what we call visual evidence. The other piece of evidence that is always persuasive, and you must look out for it, especially in commercial matters, is the contemporaneous documentation. What is a contemporaneous document? Your evidence is that there was a transaction. If someone gives details of that transaction in the witness box, oral evidence to a judge, now that witness is going to be subject to cross-examination, and your opponent may be able to make inroads. But if you said to the witness in chief, Mr. X, take a look at this document. What is that? And then the witness says, that is the contract we signed after we entered into this transaction. That's the defendant's signature, and there's my signature. Contemporaneous document evidencing the transaction. Highly persuasive. Now you know why we insist on having written agreements, not oral agreements, okay? Or there's a dispute over delivery of goods. Your witness says, I delivered these goods to the defendant's premises on such and such a date. Look at this document. What is that? Oh, this is the delivery note. It's got the defendant's signature acknowledging delivery of the goods. You see, it's brilliant. It supports your version immediately, and it's an independent piece of evidence that the judge can rely on. Never lose that opportunity. Now, once you have presented proof of your facts, the court will begin evaluating the facts in order to decide if the party bearing the onus of proof succeeded in doing so. Now, onus is a very important aspect of evidence. There are two concepts that tend to get confused. Onus is one, which means that the party who makes the allegations, usually the dominus litis or plaintiff, bears the onus of proving it. If, for instance, the evidence was of such poor quality that the judge is unable to decide which version is the more probable or more persuasive, the judge can say, look, on this evidence, I can't decide this matter. The onus is on the plaintiff. The plaintiff loses. The case is dismissed. Plaintiff pays the cost. Okay? Onus is very important. The second thing that you should apply your mind to is the duty to begin. Now, onus never shifts, but the duty to begin can shift, depending on how the defendant pleaded to the plaintiff's particulars of claim. For example, if the plaintiff relies on a suretyship, the plaintiff bears the onus of proving the suretyship. The defendant admits the signature but pleads that he signed under duress. At the trial, all the plaintiff has to do is say, here's the original suretyship, my lord, I rest my case. The duty to begin is on the defendant to prove that he signed under duress. But the onus remains with the plaintiff. The duty to begin starts with the defendant. Okay. So we have two standards. I've dealt with this. Beyond reasonable doubt. That's the criminal standard and on a balance of probabilities. But by the way, that beyond reasonable doubt is the most misunderstood standard of them all. Balance of probabilities is easy. Now you understand what it means. It simply means this evidence got 3 yeses, and the story was presented in a sequence. It is convincing because it is likely to have happened. Okay. I'll deal with the standards at a later stage, but here's the golden rule. All relevant evidence is admissible unless excluded by a rule. Now here you've got two of the 3 yeses. You've got relevance and you've got admissibility. Why they didn't add probabilities here, I don't know. This is written by academics. But just remember, for you as trial lawyers, the golden rule has 3 requirements: relevance, admissibilities, and probabilities. That's it. And to show you just how important this is, here's a quotation from Lord Brown Wilkinson, who is a English judge, a law lord, very senior judge. He was asked, he was interviewed, and he was asked, what are the main principles of judging as a judge in court? He said, the first principle of judging is dirty dogs don't win. And that's perfectly true. And what does that mean? Who is a dirty dog? A dirty dog is the one who comes to court and presents the judge with a version that is improbable. Okay? That's a dirty dog. And why is he a dirty dog? Because he shouldn't be in court. He's coming there to take a chance, hoping the judge is an ass and might believe his nonsense. Okay? Doesn't happen. Okay. So the lesson in that is the 3 yeses mean that your client is not a dirty dog. Your client's got a version that's not probable. That client's a dirty dog, and you're going to lose. You lose the case. Okay. Now there's a problem that lawyers are facing currently, and it's a growing, developing trend. And I'm telling you about it because I want you to be warned as to where our courts are going. You know that when you went to court and the judge finds your client's version to be rubbish, what do? The lawyers have a set excuse. If a judge says to the lawyer, Mr. Mokoena, do you really expect me to believe this version? What the judge is saying, Mr. Mokoena, your client's version is improbable. What is Mr. Mokwena's stock response? He says, well, my lord, those were my instructions. You've all heard of this. Most of you may have done it too in court. A judge or a magistrate says, but can I accept that version? It's nonsense. No, my lord, those were my instructions. Well, that's changing. We got away with it. A judge said, those are your instructions. I'll find against this person and I'll punish him with a cost order. Well, things are changing because the judiciary is thinking courts are a limited resource. You can't go to court just because you can, okay? You only go to court if you have a legitimate dispute that requires a trial or a hearing of some sort. If you go to court with a rubbish version that had absolutely no prospect of success. You are the dirty dog, and you are going to pay the costs. But now judges are thinking, but hold on, these lawyers, they're officers of the court. They know this is a nonsense version. Why did they bring it to court? Shouldn't they be punished? Shouldn't they be disciplined for doing so? Well, that's a debate that is going on at the moment in this country. And let me assure you, in England, if the client is a dirty dog, the lawyer ends up getting disciplined on the basis that, listen, you're an officer of the court, you should not have come here with that rubbish, you wasted resources, and you're going to be punished. Be very careful about that. It's coming. It's going to happen soon, where a judge is going to say to a lawyer, look here, your version is bizarre. You should have known better. You're an officer of the court. I'm disallowing your fees. That's what's happening in England. In Canada, it's happening in Australia. Now, there's a good article I want you to read. Please read it. It's excellent. It's written by Judge Owen Rogers. Okay, he's currently sitting in the SCA, I think. If you Google it, you'll find it. It's The Ethics of the Hopeless Case. He deals with this problem that lawyers have. That client says, here's my story. You don't believe it, but you say, well, those are my instructions. I'm going to court. I'll make some fees. Okay? That's what drives it. Well, this article questions that attitude, and it must be questioned. Okay? If you Google it, you'll find it, but you'll find it in the December 2017 edition of The Advocate. It's the magazine that's published by the General Counsel of the Bar, the GCB. Okay, now let's move on to the first of the three yeses. Evidence must be relevant. So when is it relevant? I've put up some definitions. When it has any tendency to make a fact more or less probable than it would be without the evidence. Now that's what I've been explaining to you all morning. The evidence is relevant if it assists the judge in working out if the version is more or less probable than it would be without that evidence. So you will see that the third yes features prominently. If the judge hears the evidence, it's admissible, but the judge doesn't accept it as likely to have happened. So what does the judge say? It's not probable. Remember, the definition is not more or less truthful. It's not about the truth. It's about the probabilities. The fact is of consequence in determining the action. In other words, you presented evidence which amount to a fact or a set of facts which will assist the judge in resolving the dispute. It is admissible if it relates to the facts in issue or to circumstances that make those facts probable or improbable and has been properly obtained. Okay? Easy to understand, and now you know how to apply it. Okay? Just think of the three yeses. Now we know that evidence must be relevant to issues before the judge and must be admissible in its form. That's the golden rule. If you breach the rule, you fail. Evidence, if it is to be received, must be logically relevant and of sufficient probative force to warrant its reception. Now let's break that up. Before evidence can be received, I've told you it must pass those get the three yeses. And there you see it, logically relevant. First yes. Of sufficient probative force. What is meant by probative force? You must have heard of the phrase probative value. Lecturers like using that at university. They'll say the evidence must have probative value. They like saying it because it makes them sound smart, you see, but they don't know what it means. Probative values or probative force simply means weight as proof of a fact. What value can a judge give this evidence as proof of a fact? Now, that's what a judge does. Now, a judge will only consider probative value if you got the third yes. In other words, if the version is probable, there's no point in asking or evaluating evidence as proof of a fact if the judge doesn't believe the version in the first place. You see how important it is? So, for trial lawyers, the version of what happened takes center stage. This is where the persuasion happens. Okay. So, you know, as a lawyer, I always say to lawyers, the most important question that you can ask your client is, what happened? Tell me what happened. And now you sit back and listen. And as you listen, you are testing the probabilities of the version. Remember, you're going to be hearing this version for the first time. You don't know what happened. You don't know. Client's going to tell you. And if it doesn't make sense, then you must fix it. If you can't fix it, then you start explaining Rule 41A to your client, okay? The facts or the evidence must amount to a version that is probable in relation to the facts and circumstances of the case. The judge must be persuaded to find that your version is likely or most likely to have happened. And I say the judge is not looking for the truth. The judge is looking for the probabilities. Never forget that. If the judge finds your version to be improbable, you lose. If your witness presents a version that is improbable or implausible, you lose, okay? Some of you may have been listening in on this murder trial, the Senzo Miiwa case. Now, if you want to learn about how you don't present evidence to a judge, go and listen into that case, okay? You've got some real specimens there that you can watch. Let's take this forensic expert, Musia, who turns up at a crime scene where someone was shot dead. But he doesn't notice a spent bullet. He does not retrieve it. He comes back the next day or who knows how many days later. Now, if it is a crime scene and a gun was used, what are the probabilities that a forensic expert did not notice that there's a spent bullet on the scene? I mean, come on. It's possible, but how likely is it? Now, if you listen to the one advocate who knows a bit, the lady, what's her name? Sholo, I can't remember her name. She asked questions that were directed at this witness based on what is likely to have happened. So you see how the probabilities not only assist you to determine the strength of and weaknesses of your own case, but it assists you in doing the same thing to your opponent's case, and that gives you the ammunition for cross-examination. Okay? So here's the test. I've been through this. There's your 3 yeses, the 3 ticks. You fail any one of those, you're out. Okay. I explained to you that when a judge says, I accept a witness's version, I find it to be true. He is not saying it is true. He's merely saying, for purposes of this hearing, I find it to be true. Okay. Now, once you present, well, listen, okay, let me give you a short break before I move on to evaluation. 10 minutes. Can we get back at 10 to 1? Okay, 10 to 1, and then we'll resume. Betty, should I get started?
Judge, you said 10 to 1.
Is it 10 to now? Oh no, a few more minutes.
Yes, I think you gave him a little bit a longer break than 10 minutes.
Okay, I'll catch it up later.
Okay, then.
Right. All right, can we start? Betty, can we start now?
We can start, Judge.
Right. All right, let's resume. I want to start by briefly referring you to the definition of the word evidence, just to illustrate the point. Testimony, facts in support of or for a conclusion. That's one definition. Another definition, information given personally or drawn from documents tending to establish fact. Now, if you look at those two definitions, you can see quite clearly evidence is about facts. That's what it is, okay? And then we have the lawyer's definition. The first two definitions are straight dictionary definitions. Statements or proofs admissible as testimony in court. Now, you will notice that by definition, evidence is about fact, okay? Now, sorry, I'm having some problems here. Okay. So evidence consists of oral statements made in court under oath, what we know as lawyers as oral evidence. You call a witness to testify. It also includes admissible documents, objects, exhibits that are produced and received in court. One of the things I did emphasize is that you should, as far as possible, use visual evidence. You know, visual evidence can turn a case on its head. I can give you, let me give you a very good example of this. Most of you are probably aware of this controversy in the United States where white police officers were shooting black people, black males. And the power of visual evidence was displayed in one of those cases. What happened is that a black man was driving his car and he had a crack on his taillight, just a crack, but he's black, so obviously the police pulled him off and he got into an argument with the police officer. And what happened is that this black driver was shot dead. He was shot 5 times. So the police, this incident happened next to a park. So it was a fairly quiet place. The police obviously thought no one saw what was happening. And they came up with a version. And obviously it was self-defense again. How you shoot someone 5 times in self-defense, I don't know. You see, the probabilities were against that. But the police chief went on to national television the next day because there was a enormous protest about this thing. And he gave the version. He told the media, told the people that this is what happened. The policeman came under attack and he acted in self-defense and shot this person. Well, what they didn't know, the police, was that on one side of the park, there was a fence there. And on the other side of the fence, there was a woman standing there. And she had a cell phone. And she videoed what happened on the scene. And after the police made their version known, she put this video on YouTube. And what it shows is the black man running into the park, running away from the police officer, who then draws his firearm and shoots him 5 times in his back. Well, that's a very different version to what was given by the police. Well, I can tell you the police were so embarrassed by this video that they quickly went and settled with this person's family and tried to hush it up, but the damage was done. You see, visual evidence. Whereas, let's assume there was no visual evidence. Let's say there's this woman came forward and said, I saw what happened and I'm willing to testify. Right, so she testifies and starts getting hammered under cross-examination, which can happen. And the jury gets convinced that she's not being truthful. And the police's version could be accepted. But now they have the video. You can't cross-examine the video. It's visual evidence, and it is highly persuasive, okay? Always look for visual evidence and contemporary documentation. So, why do you present evidence? To provide proof of a material fact. What is a material fact? It is a fact that you require to establish your cause of action, okay? So in a contractual dispute, your material facts are that the parties entered into a contract, it was a written agreement, the terms are recorded in the agreement, and that the defendant committed a breach of the agreement. The dispute will be breach of the agreement. So plaintiff will have to present proof of the fact that defendant committed a breach. And the proof will come from evidence of a version that tells the judge that pursuant to the contract, this is what the defendant did and it amounts to a breach. Okay. Now, what I decided to do here is also give you the meaning of fact. Now, you know, if we were in an in-person lecture, I would put the question to you first. I would say, define fact. What is fact? And the answers I usually get is someone will say it's the truth, it's what happened, and it's the version, and so on. Well, within the context of a judgment, when does a judge say, I make a finding of fact? What it means is, fact is proof to the satisfaction of the court. Please remember that. When you say to the judge, make a finding of fact, you must be able to show the judge that you have presented proof to the satisfaction of the court that that fact exists. Now, evidence is used at trials to prove or disprove certain facts that would tend to show whether something was true or not. Now, there are 4 types of evidence by which facts can be proved or disproven at a trial. Now, these are the types of evidence, and I'll take you through each one of them. There's real evidence, demonstrative evidence, documentary evidence, and testimonial evidence. So, not all of these types of evidence carry the same weight. As I told you, weight or probative value means value as proof of a fact. For instance, real evidence may be more believable than demonstrative evidence. For instance, an eyewitness account of what happened is far more convincing or persuasive than if one had to establish the same facts through circumstantial evidence. In other words, proof through what we call in circumstantial evidence, it's where various facts are presented from which you make an inference or you draw an inference. It's what we call inferential reasoning. Direct evidence is far more persuasive than that. It's the judge's role to weigh each type of evidence and make a determination as to the believability of the evidence presented. Okay. Now, the judge makes a determination. A judge cannot say that is the truth. The judge will say, I make a determination based on the probabilities of the version placed before me. So real evidence is visual evidence, and it can be persuasive. Visual evidence, I told you time and again, is highly, highly persuasive. We'll give you one other example you can relate to. Let's assume it's a criminal case, and the prosecutor wants to prove a case of assault with intent to do grievous bodily harm on the complainant. Now, you all know that there'd be a district surgeon's report called a J88. And in there, there's a description of the wound that was inflicted. So, for example, you will see a little diagram of a person's face and a mark where the wound was inflicted. And then there'll be a description, something like, there is a 5-centimeter laceration over the left cheekbone. Right. Now, you read that. What does it do? Okay, so there was a laceration. But I tell you what, now give the same magistrate or judge a color photograph of the wound taken shortly after it was inflicted. So now what the judge is seeing is the face of the complainant with a gash across his cheekbone. The face is swollen, his eye is closed, and it looks terrible. And when the judge looks at this photograph, the judge goes, oh my gosh. Do you know what happened? Let's imagine the photograph out of this thing. So the judge says, 5-centimeter laceration. No, I should give him a 800 Rand fine. But now, put the photograph in. The judge looks at the photograph and the judge goes, oh my God, 3 years imprisonment. It is as stark as that. That's how effective visual evidence is. Real evidence is usually admitted because it tends to prove or disprove an issue of fact in a trial. In other words, like any other evidence, it must be relevant. Real evidence is usually involved in an event central to the case, such as a murder weapon, clothing of a victim, fingerprints, that sort of stuff. All the stuff that we now know police F up. You've probably seen this on television. Okay, actually they do. In order to be used at trial, real evidence must be relevant, material, and authentic. Now, the process whereby a lawyer establishes the basic requisites is called laying a foundation. It is accomplished by calling witnesses who establish the item's chain of custody. It's what we call chain evidence. You see, if you use visual evidence, your opponent may object to its use, which means then that you have to prove its authenticity. Being relevant and material is the easy part, but authenticity may be a problem. What we expect lawyers to do now under case management, we say, do not, if possible, find yourself having to prove the evidence in court. What is expected of lawyers now is that they must get together and agree on the admissibility of the exhibit. This is done at a pre-trial conference, which is minuted, and If you are unable to agree, only then do you record that no agreement was reached and that the party intending to use the exhibit will now have to prove it. But be careful. If you want to use an exhibit and your opponent says, nah, I'm not admitting that video, it must have been tampered with. You must ask your opponent, on the basis of what facts do you say that this evidence was tampered with? What is the factual basis? I need to record it in the minutes. If your opponent doesn't give you a basis, then you say, do the following. And please remember this. You say, you have not indicated why you object to the admissibility of this exhibit. We are now going to present proof in court. In the event that you do not challenge my witnesses, I will be seeking a punitive cost order against you. Okay. Minute it. And in your opening statement, you will already tell the judge you intend to use a number of exhibits. In respect of this particular exhibit, my learned friend, and you always say learned friend, what you mean is that idiot over there, refuses to make an admission, and he has given no basis in fact for the refusal. I am placing on record, my lord, that if my witnesses are not challenged, your lordship will be called upon to make a punitive cost order. That's it. Do that, okay? Then the stupid games will stop. Mostly with visual evidence, it's very difficult to challenge its authenticity. So if someone challenges it, there has to be a rational reason based in fact to challenge it. If they can't, well, then you know that they are just playing the fool. They're trying to delay, or they're trying to take advantage of the fact that maybe a witness has disappeared and you won't be able to authenticate the exhibit. So now, if there is a dispute over admissibility, this is what I'm saying. You are expected to resolve it at a pretrial conference or case conference. You are not expected to use court time squabbling over admissibility unless there was no other way. Now, those of you who litigate in divisions where we have introduced case management, if you have a case manager appointed to your matter, then don't have a fight with your opponent. Your opponent says, no, I'm not admitting this. You'll say, okay, we will take the matter to the judge, to the case manager. You will convene a meeting with the judge. You'll prepare an agenda, and on that agenda, you will deal with admissibility of exhibits. And at this case conference with the judge, you will say that, look, here is this exhibit. They refuse to admit it. I will require at least 4 witnesses to prove it. I can't see any basis in fact for challenging those witnesses. My learned friend will not tell us. The judge will simply look at your opponent. He won't even say a thing. Will say, what's your problem? If your opponent doesn't come up with a rational reason based in fact, the judge will make a ruling right there and say, okay, this is admissible. Okay, now you can get ready for trial. Demonstrative evidence, charts, diagrams, demonstrate or illustrate the testimony of a witness. It is admissible when it fairly and accurately reflects the witness's testimony and is more probative than prejudicial. So again, charts, diagrams, it's part of visual evidence. It is highly persuasive. diagrams and maps where there's a dispute over which involves a scene of an event that's relevant. To have a diagram, charts, photographs, aerial photographs, Google Earth, brilliant, works really well. It's admissible when it fairly and accurately reflects the witness's testimony. So in other words, it must support the witness's testimony. So the oral evidence is supported by the visual evidence, and it must be relevant and assist the witness's version. So maps and diagrams of a crime scene, charts, graphs that illustrate physical or financial injury to a plaintiff are examples of demonstrative evidence. Witnesses create and use demonstrative evidence at trial, and opposing counsel may use the same evidence to prove contrary positions. This form of evidence will be subject to the rules of discovery and will require agreement. Now, I've dealt with that. The process of discovery, Rule 35, and agreement as to admissibility happens at a pre-trial conference. And if you require admissibility of a number of facts, it doesn't have to be visual evidence. It can be a simple fact like that the robots were working on such and such a date at that intersection. Will you admit it? Okay. You might need 2 or 3 witnesses to prove that. Well, always 2 weeks before the pre-trial conference, prepare an agenda for the conference. Attached to the agenda must be a list of admissions of fact that you will seek. Send that to your opponent. The reason I say do it 2 weeks before, it's because I've been to hundreds of pre-trial conferences. When you ask your opponent for an admission, the usual response you get is, we'll take instructions and revert. And then they never revert. And then you have to have another conference. It's just waste time and costs. When you send it in two weeks, they say, we'll take instructions and revert. Then you must say, can you tell me why in 2 weeks you were unable to take instructions? Please tell me, I need to minute this for the judge. The nonsense stops immediately, okay? Documentary evidence, you're all familiar with documentary evidence. It is presented, again, to prove or disprove an allegation at trial, a material allegation. The documents can be from a vast number of sources, diaries, letters, contracts, newspapers, any kind of document you can think of. There are restrictions and qualifications for using documents at trial, as there is a need to make sure they are authentic and trustworthy. Right, the authentication process for documents. Well, if it is a traditional hard copy type document, like a contract that has an original signature of the parties, that is very easy to authenticate. You discover it, you send a copy to your opponent, and then at the pre-trial conference, you present them with the original or invite them to inspect the original even before the pre-trial conference. Then you request an admission. And if it's not forthcoming, do what I told you to. Put them into trouble. Now, the one area which you need to put some work into, it's not difficult, is electronic documents. You cannot believe how these days I can't think of documents that are produced manually. Even a small business, someone running a tuck shop, will produce electronic documents like a receipt or a delivery note. These things are all done electronically now. How do you prove them? The way you prove electronic documents, there's a process. But before I go into that, just remember the principle is the same. Firstly, you only discover documents that are relevant to prove or disprove an issue. Now, most of you have seen discovery affidavits in your offices, and the bundle of discovered documents. It's huge, that much. And you trundle this off to court and you hand it to the judge, and then in a 3-day trial, you might use 2 pages from there, because that's all that's relevant. This business of discovering all the correspondence and everything that you can lay your hands on is nonsense, and it's just there so that attorneys can generate fees, okay? So you put together a 300-page bundle, and then you say, on perusal of 300 folios, so many rands. Nobody read those things and nobody perused them. They've just been thrown into the schedules and they're produced in court. I'm just warning you, if you do that now, you will get punished, or your costs will be disallowed. I've seen that happen in court. I've done it myself. So this business of discovering everything is nonsense. It must be relevant to the issues, and discovery must be proportionate to the circumstances of the case. I mean, if you've got a case involving, I don't know, 800,000 rand, and now you want to discover 5 lever arch files of documents. I mean, that's ridiculous, okay? We don't do that anymore. Now, by the way, in England, they've taken it a step further. They say there that the attorneys on both sides have to get together and agree a budget for discovery. So they must agree, we're going to spend so many £100 on discovery. If you exhaust that fund, you're getting nothing more unless you approach the judge, the case manager, and he approves an extra budget, because it got out of hand. You must have heard of this thing called document bombing, where the one party overwhelms the other side with so much documents that they're forced to settle. Well, now we have electronic documents. These documents reside in the hard drive of a computer. That's where they're produced, and copies are then printed or emailed. Now, I'll tell you a funny story. It'll illustrate the point. I was in Bloemfontein. Unfortunately, I have to go there from time to time. In Bloem, I was presenting a course to attorneys and advocates. And during lunchtime, this happens always, someone comes up and wants some guidance on some problem they're having in the office. Now, this attorney had a funny problem. He said that he acted for he was acting for a client, asked him to sue for goods sold and delivered in the magistrate's court. So he sent out a summons, and there was no appearance to defend. So he applies for judgment by default. Now, you know, those things are done by application. You don't appear in court. Well, the magistrate refused his application because he had not attached the original invoice. Now, his problem was, what do I do? What is an original invoice? So I said to him, do you know what metadata is? No, he doesn't know. Oh, by the way, don't think he's a Free State pampoon. That's why he doesn't know what metadata is. I had a group of 40 lawyers here in Midrand, and not one of them knew what metadata was. And they were young people, not old fools like me. So metadata contains the information about the document. Whenever you produce a document on a computer, it has software which logs what work was done on that computer from the point where on the document, from the point when it is produced, if it was amended, how many times it was printed, all of that information about that document is there. So in order to prove a document as authentic, there's no such thing as an original document now. You have to produce the metadata and show that this thing hasn't been tampered with, and what you emailed or printed is a true copy of what's on the hard drive. So now I'm explaining metadata to this attorney, and then he looks at me perplexed. And then I realized what the problem was. He said, listen, there's no chance that a magistrate here in Bloem is going to even understand what metadata is. How am I going to explain this to him? So now I start telling him how you go about proving metadata. So then I stopped. I realized I'm wasting my time. So I gave him advice. I said, listen, but do you have a stationery store in Bloemfontein? He says, yeah. He says, I said, go there and get a rubber stamp that says original on it, an original rubber stamp. I said, go and get a stamp and hoy an original stamp on the same invoice that you sent and give it to the magistrate. And he did that. I met him sometime afterwards. He says, hey, I got judgment. So, I mean, it's as ridiculous as that. Now, it's very important for you as lawyers to understand how you obtain and prove into evidence, admit into evidence, electronic documents. I co-wrote a book. Here it is. It's called A Guide to E-Discovery in South Africa. It's very useful. It's very practical. I co-wrote it with Terry Harrison, who is a solicitor from England, who is a expert on electronic discovery. You want to get it, you have to know how to deal with electronic discovery, because there's no other kind of document that comes to court anymore. So get it. By the way, you must be aware of that case. It's been running for about 10 years now, of McCarthy versus Vodacom. It's known as the Please Call Me case. He eventually won that case. The plaintiff, McCarthy, he claimed to have invented the Please Call Me technology, and Vodacom made millions out of it, billions. So they didn't want to compensate him. They first lied that it was someone else who invented it. But eventually the Constitutional Court found in his favor. But the dispute now, and by the way, it's still carrying on, is the quantum of the damages that he should get. And they made him offers, which he poo-pooed. He says too little. Eventually, the matter went to court, and you should read this judgment. It's a judgment of Collapin J, where they said, look, this information that he wants is not in its original format, and it has been archived, and it's impossible to access. So can you imagine, they were asked to produce the data for each please call me call that happened from the time it was invented to current date. I mean, it runs into millions and millions of documents, electronic documents. And they argued the matter in court, and Vodacom was ordered to give access to that. It's a monumental task, but that's an extreme example of what can happen if you have to authenticate documentation. Then I dealt with contemporaneous documentation. Judges love it. You always give a judge anything that they like. They like contemporary documents because it provides reliable proof of the facts. Now, testimonial evidence is when a person gets onto the witness stand and says something or relates a story, a narrative. It is simply a witness giving testimony under oath, okay? It is the testimony of an eyewitness, someone who testifies from personal knowledge, and the evidence must be relevant, admissible, and the version must be probable. You do not call to a stand testimonial evidence that does not get the 3 yeses. Must be relevant, must be admissible, must be probable. The relevance and the admissibility, most lawyers have no problem working that out. Okay, they know that when it's hearsay, they know it's hearsay. If it's inadmissible opinion, they know it. Not a problem. Where they fail is in making a proper assessment of the probabilities. The third yes. You get that one wrong, you are going to lose because the judge will not find the version to be probable and will reject it. So the trial lawyer's view, evidence covers the burden of proof, admissibility, relevance, weight and sufficiency of what should be admitted into the record of a legal proceeding. This is what lawyers do. And I've been dealing with each of these elements as we go along. Now, let's get to the heart of evidence. Now that you know the facts, what do you do with it? Now, the first step always is to obtain all the facts. That's the first step for any lawyer. You know, lawyers have the saying, they say that we have to take instructions, or we are taking instructions. I have to take instructions. What that really means is that I have to obtain the facts. Before you present the evidence in court, you have to evaluate the evidence. And you have to decide how you will present the facts. And you will also decide what facts to present as being relevant to the issues. It must be relevant and persuasive. And I repeat, the version must be probable. Now, it's very important for you to listen to the oral evidence that's available to you and make an evaluation yourself. You're a lawyer. You have the same skills as the judge has. You can work out if this version will fly in court. It's the test of the 3 yeses. And now I come to another aspect of evidence that is ignored. It really is. And lawyers pay the price for it. It's called developing the case concept. Now, you must have heard of this thing called the theory of the case. The American lawyers call it the theory of the case. We call it case concept. Before you evaluate the evidence and work out how you will present it, you must understand your case concept. Simply because you will be navigating your way through a trial without a chart. You know, it's like a pilot trying to find his way across the ocean without any charts. You will get into trouble. So what is case concept? In plain language, it means what happened according to your client's version of the facts. Once you have a firm understanding of what happened according to my client's version, now I know what to do, because that tells me what facts I need to prove my cause of action. It also tells me which witnesses to call and which witnesses not to call. It also tells me which questions to ask in court and what questions not to ask. So without a case concept, you are basically fiddling in the dark, okay? You are winging it in court. That doesn't help. Now, I found a definition of theory of the case or case concept. This is Thomas Maue. He's a QC. He's a silk who practices in England and in Australia. Now, I'm going to take you through this because it sort of encapsulates everything I've been trying to tell you. And I'm going to ask you after today to go and read this again and again and get to understand it, because without it, you could get into trouble. Theory of the case is a logical, persuasive story of what really happened. Logical, persuasive. Must be presented sequentially, must be probable in relation to the facts of the case. It is your position and approach to all the undisputed and disputed evidence that you anticipate will be presented at the trial. So your version must account for the undisputed facts as well as the disputed facts. I told you, if the undisputed facts do not support your version, you've got a problem. Okay. Developing a theory of case is the process of integrating the undisputed facts with your version of the disputed facts. You see how important this is? I told you from the start, write down the undisputed facts. Now weave this into your version of the disputed facts. In order to create a cohesive, logical position which illuminates the evidence in the most favorable light to your client. This position must remain constant or consistent through each phase of the trial. So when your opening statement, you must be aware of what your case concept is, what happened. When you lead the witnesses in chief, your case concept tells you what evidence. When you're cross-examining your opponent's witness, this tells you what to ask. And then when you present final argument, you will show the judge that your case concept has been proved and the onus has been discharged. When at the end of the trial, the judge is faced with the question, what really happened? Your position must constitute the most plausible explanation. Now you get it. Not your position must constitute the truth, or your position must constitute what actually happened. All the judge needs to be persuaded is that it is the most plausible explanation. Okay. That is the third yes. It is your client's version of the disputed facts. It is your explanation how events are likely to have happened. As a lawyer, you need to know what really happened. Now, I've spent 40 years of my life in courtrooms. And I can tell you, I've seen case after case where the lawyers kicked off, started leading a witness, actually didn't know what the case concept was. They were not sure exactly what their version of the facts are. So they call a witness and they hope the right stuff comes out, okay? And usually it doesn't. You have to lead the witness, and I'll show you how you can do this later. So you have to do your own evaluation of the facts before you even write your particulars of claim. I know you think I'm talking nonsense because nobody does that. Well, I've got news for you. The new lawyers, the smart ones, are doing exactly that. Because if you want to win a case, that's what you do. You want to be successful, you want the judge to accept your version, this is what you do. You get the facts, you obtain as much of the available facts that's there, which includes documents, visual evidence, all of that stuff. But once you have it, I told you, apply the 3 yeses first. When you've passed that, now you have to do an analysis. You have to analyze your own facts like a lawyer. You're not doing this because, I like my client, is paying my fees, I'll accept anything he says. No, it's a very objective, professional procedure. First of all, establish a chronological sequence of the facts and the documents. I told you that. Essential. Never consider facts that are all over the place. They must be in a chronological sequence. Now establish the main dispute or potential disputes between the parties. You know, you may not have the benefit of pleadings at this stage, but it's essential for you to do this. And it doesn't take genius to work out from your client's version what is likely to be the dispute from the other side. Okay. Identify the main disputes. Now, look at the evidence, the facts that are available to you, and ask yourself, which facts support my client's version of what happened? Those are what lawyers call the good facts. Make a note of that, because those are the facts you want to prove in court. Now identify those facts that don't favor your client, but they favor the opponent. It's like the skid mark. Doesn't favor your client's version. Make a note of that. Those are what we call the bad facts. Now, when you've done that, looking at you have to do that by looking at each witness and asking which facts support my version that come out of this witness, and what are the facts that support my opponent's version. How am I going to prove the good facts? How am I going to undermine the other side's good facts? That's what you're thinking now as a lawyer. Now, I'll go through this quickly. Why do you sequence the facts? It is absolutely essential. It helps you to define your client's cause of action or defense. It helps you to manage a witness. It helps the witnesses to tell the version. Now remember, your whole purpose of going to court in the first place is to present a version to the judge which is persuasive. And you present that version through the mouths of witnesses. Now, I told you, when you have a chronology document for each witness, it works brilliantly. Because when you prepare your witness in consultation, the witness must tell you the version in a sequence. You would have written it down in a written statement, and you will give it to the witness to say, refresh your memory and remind them. You will see that this thing is in a sequence from start to finish. That is how I want you to present it in court. Now take a look at this document. You will present the witness with a chronology document that you wrote. It will contain just the material events with the date and time next to it. The witness then reads that and understands it. But now you say to the witness, when I lead you in court, I will lead you according to this list. And that's where your chronology document becomes a really effective instrument for you. One of the problems lawyers have in controlling a witness in chief is they don't know how to move from one fact set to the next and then to the next in a logical, chronological sequence. You'll get this nonsense happening in court where you say to the witness, Mr. X, you were on the scene. Yes, tell the court what happened. And the witness talks. and then stops. Then you say, and then what happened? And what happened next? You lost control. The best way is for you to have a chronology document and tell the witness, I will be asking you according to this. I will say, on such and such a date, an incident took place. Tell the court about that. You take a look at this document. Hand up, refer to the bundle. What is that document? What is the date? So you have what is called a headline, which you give the witness. In other words, you're telling the witness what you are going to deal with, and then you ask the questions. And your chronology document is in front of you. It's no use having the witness's statement in front of you because it acts as a distraction. You don't maintain eye contact with the witness and the judge. Very bad, okay? So it helps the witness to tell the story. You control the witness, and the witness understands the version and presents it with order, logic, completeness, and accuracy. That's what sequencing does. Sequencing joins events together in a way that invests them with meaning. That's the important thing. If you've sat in court often enough, you would have noticed that sometimes the judge will be listening to this evidence for about half an hour and then looks up and says, Mr. Mokoena, I don't know where this is going. What's the relevance of this? So the judge has not followed the evidence. The judge doesn't know why you call this witness. It's because the evidence has no meaning. Meaning in the sense that the judge can't see the relevance of that evidence to the issues before him. How is this helpful? When a judge says, why did you call this witness? The judge is saying, how is this witness helpful to me? I don't get it. The lawyer made the mistake, okay? So sequencing puts the events together in a way that the judge can follow it and it has meaning, okay? And it's how evidence is managed in court. All evidence is managed in court from beginning to end. Now, you can test this. Go and read law reports. Very exciting, as you know, but go and read them. You're supposed to. You read judgments from experienced judges. You will see that they will state the issues. They'll have an introduction, state the issues. Now they will deal with the factual background, the facts of the case. And you will see without fail, they will set it out in a chronological order because that's how judges do it. And that's how judges want the evidence to be placed before them in a sequence. Sequencing helps you to focus on the important facts and events. It helps you to focus on those facts that are relevant to the issues. It keeps you organized. Being organized is so important when you're leading a witness in chief and when you're cross-examining your opponent's witnesses. It keeps you relevant and it avoids misdirection. That's very important. You only succeed if you present the facts in a manner that is persuasive. Now, you can see we're just building up all the time to the things you have to do in order to present your evidence in a manner that is persuasive, okay? And I've just said, as a lawyer, always think sequentially. You know what's important, what's so exciting about law? What's exciting about law is that it requires you to think, to apply your mind. That's what makes it so exciting. You know, for everything you do as a lawyer, you must think it through. What are the consequences of this? If I make this submission, how will the judge deal with it? How will my opponent deal with it? If I present this evidence, what effect will it have on my case concept? You're thinking all the time. You're not some moron with an LLB who spends his day copying and pasting from precedents, then you're not a lawyer. You shouldn't be there, okay? You should maybe open a Chisam Nyama or something. But if you're not thinking it through, if you're not applying logic, you have to apply logic all the time. You're not being a lawyer. I'm showing you step by step how the logic works, how you apply the logic. Now, here's more of the logic. You need facts to establish the cause of action or defense. Now, I know I'm sounding like a stuck record. You don't need a precedent to establish your cause of action or defense. You need facts. If you have to consult a precedent, please do it after you've accumulated all the relevant facts. Then you need the facts to establish proof of each material fact that makes up your cause of action. You need the facts to identify the dispute. Your job as a lawyer is to investigate and obtain all the sources of fact before you issue the summons. Very often, client never covers all of the information, but that's where your skills as a lawyer comes in. Where, again, you're applying the probabilities. An accident took place in an intersection. You know that potentially there are witnesses there. Someone saw it. Someone may have videoed this thing. You are going to go and investigate. As a lawyer, you investigate the facts and then you present them. Okay. You will be often, and this happens all the time, be faced with what we call a lack of factual resource. In other words, your client doesn't give you enough or sufficient facts. You must have heard this at university, the sufficiency of evidence. What does it mean? It means, do you have enough facts to place before a judge in order to discharge the onus of proving an element of your cause of action or defense? That's what it means. You will have to investigate and go look for the facts. And once you've obtained facts, you have to look at the admissibility of the facts and then reliability of the source of the facts. Now, here's another concept that you learned at university, that evidence must be reliable, or the reliability of evidence. What does it mean? To a practicing lawyer, it only means one thing. It means, can you call a witness who can reliably present the facts to a judge? Judges measure reliability in various ways. What reliability actually means is, did the witness have enough of an opportunity to observe an incident and then to reliably account for it before a judge, maybe 6 years later, okay? So there are a number of factors judges look at. Where was the person standing in relation to the incident? What was the lighting like? Those of you who do criminal work, you will know that in our courts, the same defense is used in bloody every case. It's called the shaggy defense. It wasn't me. It wasn't me. I wasn't there. It's always a case of mistaken identity. Mistaken identity is very much dependent on the reliability of the identifying witness. So you look at things like lighting, distance, weather, obstructions in your view. Judges will test that. Now, as a good lawyer, you will deal with those things if you are leading the evidence. You will also remember to use those factors when you're cross-examining in order to discredit the reliability of that evidence. Okay. And I've got a warning there. Never accept everything that your client tells you. Attorneys generally are more objective when it comes to witnesses, but they're not so objective when they're listening to their own clients. There's this bias that kicks in immediately. You take on someone as a client, right? I'm on his side. I've got to fight for him all the way. Nothing wrong with that attitude. But remember, you'll have to go to court with this thing. And you can only succeed for your client if you've passed the 3 yeses. Okay? So never accept everything they tell you on face value. Question it. Okay? Where's the document? Oh, I lost it. Or where did you lose it? Can't you go and look for it? Can I assist you in finding a copy? You know? And then there's this other problem that lawyers make. At this stage, do not make assumptions. Do not assume something to be a fact. Make sure you can prove your facts. Now, in any cause of action, you will have to prove a set of material facts. In 99% of the cases that you will do, not all of those facts will be disputed by your opponent. They will admit most of it, but there'll be a dispute over maybe one material fact or two. You must never assume that your opponent will make an admission. Always be ready to prove a fact. You only relax when your opponent says, yes, I will make that admission, and that happens in a pretrial conference. Okay. If you get all the stuff wrong, you are going to be in trouble. I'm going to deal, Betty, are there lots of questions?
Judge, I sent you some. Nothing after that.
Okay, fine. Let me deal with this, then I'll come to the questions. Here are some practical suggestions. There's a tendency to leave trial preparation soon before the trial date. Now, you know what it's like. 2 weeks before the trial, you're scrambling around for witnesses and so on. This is not what good trial lawyers do. Before you issue the summons, the trial is now 3 or 4 years away. Be alive to the inherent contradictions of fact in your own case. You must be prepared to explain it. Now, one of the things that a technique used by judges and lawyers to discredit evidence is to look for contradictions, material contradictions. Where you find these contradictions, you know you can discredit the evidence. Now, if you see contradictions in your own client's version, if your client's witness that they bring along contradicts what your client is saying, now you'll be a bloody idiot if you don't pick that up and explain it, and you end up going to court and you call that witness, and they in court, they give the same version, contradicts your client's version, and you lost the case. Take statements from witnesses as soon as possible. I've seen people, lawyers running around looking for witnesses and taking statements on the week of the trial. Now, there are some advantages here of taking the witness's statement at a very early stage. And never forget this. Never forget it. In this country, when you get a witness, your client brings a witness, and the witness gets 3 yeses, and you want to call this witness. The fact that you got 3 yeses doesn't mean the witness is going to turn up in court. That's the big problem here in this country. What you want to do, you want to ask the witness to sign a written statement. This is crucial. It doesn't have to be under oath. It doesn't have to be an affidavit. Just a normal statement written sequentially, and you say to the witness, please sign this statement. Now, one of two things will happen. The witness will say, boy, I don't sign anything. Well, you can be bloody sure that witness will not turn up in court. They'll say, oh, I'll be there, but they'll never turn up. They'll tell you they had a funeral to attend, okay? But there's another big problem in this country. The witness doesn't turn up because the witness has disappeared. You don't know where the witness is, or worse, the witness has died. Now what? The importance is that if you have a signed statement, you can use the exception to the hearsay rule and admit that statement in court. Those of you who are not familiar with this by now, please go and look it up and read it. I think it's section 3 of it's called the Law of Evidence Amendment Act. It creates an exception to the hearsay rule. What that exception does is it allows you to admit into evidence a statement where a number of conditions are met. You are unable to find the person has died, it's relevant, and so on. There are about 7 different requirements stipulated in the Act, and they are not difficult to comply with. And there you go. You can't find the witness, a material witness, but you manage to get the evidence in. And the advantage you have is that you can't cross-examine that statement. It's there before the judge, and the judge will weigh it when he weighs all the evidence. So you absolutely must, in this country, take a written statement, get it signed. I keep saying this country because in this country, people do disappear. And between taxi drivers and aides, the chances of your witness being alive on the day of the trial are not that great. So make sure you have it in writing. You must, at an early stage, gather and preserve the relevant documentation, especially when it comes to electronic documents. Find out where these things reside. Go and go and copy the hard drive. Put it in a safe location where no one can get access to it. Make sure you get documentation in the native format and then preserve that for the trial. Remember, the trial could be 3 to 6 years down the road. Where appropriate, visit scenes, take photographs, measurements, prepare sketch plans, obtain all kinds of visual evidence. Now, this is not something you do a month before the trial, because it's too late. If it involves a scene, like a dispute over a building contract, defective work on a building, or a floor collapsed, or an accident, the scene of an assault. These are all cases where you might potentially do an in loco inspection. Now, the best time to get the evidence is as soon as you get instructions. Our client tells you today, you're going to do the inspection the next day. You're going to take along your digital camera. You're going to take photographs. You're going to check if there are CCTV cameras. You're going to obtain the footage. You do all that. You haven't even issued the summons yet. That's a good lawyer. Preserve visual evidence and exhibits. And the advantage of this is that the sooner you obtain it and secure it, the easier it is to prove authenticity. The chain evidence will come up, will be more easy to present in court. Okay, now I'm going to just stop here for a moment and go to the questions. Right. Now, okay. Here's some questions by Advocate Schultz. How does one deal with a client like that who is clearly lying? Do you just refuse? What happens when there is an ethical duty to accept an instruction? Because advocates may not merely turn down instructions But at the same time, we cannot present rubbish to court. It's a serious conundrum. That is why I said read Roger's article. That's exactly the question he's addressing. Now, if you know that your client is clearly lying, or there's something about the version that is entirely improbable, that's the equivalent of knowing that you are going to lose. My suggestion to you is, and I understand that lawyers, advocates have this cab rank rule, and you've got to take on a client, and everyone has the right to representation and so on. But that's the change that's happening in our courts. You have a right to representation, but you don't have the right to come there with a bullshit story. Okay, just because you have a right, because those are scarce resources paid for by taxpayers. You can't come there and waste time with a nonsensical version. Now, my suggestion is, when you see this, you explain to the client that this is not going to be a version that a court will accept. You might even try this never works, but you should always try it and say, listen, I'm telling you why the judge won't accept this. Now go away, think about it. We'll make an appointment for next Tuesday. Come and tell me what happened then. So they might come back with another version. Usually it's equally improbable. It doesn't help. But sometimes they come up with something that's more acceptable. But let's say you can't get a viable version out of the client and they insist on going to court. Rule number one, never take a case like that on contingency. Never, because you will lose your money. You'll be sequestrated. Get a huge deposit. If the weaker the version, the bigger the deposit, okay? That's how it works, because you want to be covered. Then I would actually give the client a memorandum to say, I've made an assessment of your case. Here are the weaknesses. I explained the weaknesses to you. You are nevertheless instructing me to proceed. Get them to sign that mandate. Because I'll tell you why. Very often when it blows in court, the client blames the lawyer. Just keep yourself covered, okay? How does one deal with the client who changes their version of the stand? It seems to happen a lot in criminal courts. Or am I doing something wrong? Mr. Schultz, you are doing absolutely nothing wrong, because in criminal courts, accused people change their versions all the time, okay? And it's all the prosecutor once, and it's all the magistrate once, and your guy gets convicted. Now, what you do when the version has been changed, there's no way you can get around it. And for God's sake, don't try and re-examine. It just gets worse. What you do is when the version changes, and it must be a material change, all you do is you sit down and you start working out the mitigation. Stop listening to the evidence. Your guy's gone. You write them. You start preparing mitigation. Evidence like cell phone footage. Do you need an expert? How do you admit evidence of electronic evidence, cell phone recordings, and so on? This is electronic evidence. That's the first thing to understand. Cell phone recordings is electronic evidence. A video is electronic evidence. All of this is recorded on the hard drive. And then you have to get the metadata and prove it accordingly. I would recommend get my book. It explains step by step how to do this. And by the way, my new book on trial advocacy deals with this very comprehensively. It gives you case studies where it's like reading the record of a trial, where I show you exactly how you lead a witness in proving electronic evidence. Okay. Can you admit it by asking similar questions like, did you take this footage? Oh yeah, oh no, look, the first prize with electronic evidence or any other kind of evidence is to get agreement from the other side. Even in criminal trials, you can hold a case conference with the prosecutor and get admissions Like they will ask you for admissions to get admitted in terms of Section 220, I think. And you do the same in a criminal court. So the first prize is to agree. Only if you can't agree, you have to record the reason for the disagreement. They can't say, oh, no, it's a cell phone recording. Who knows what happened to it? No, there must be a basis. I'm giving you the recording. I'm giving you the metadata. Now you must admit it. So the secret, if they dispute, if you've got electronic documents, you do two things. You make the document itself available in discovery, and you make the metadata available in discovery. You invite access to the metadata. Once they've had the metadata and the document itself, then you say, will you make the admission? If they say no, then they must give you a reason. If they can't give you a reason, make a note of it and tell your opponent. You are going to tell the judge, if you are unable to challenge my witnesses, I will now ask for a cost order against you. Okay, the last thing was a comment. Look, I've run out of time now, so we'll continue tomorrow at 11. Look, you've got the manual that I gave you. What I would expect you to do is that after tomorrow, you will spend time reading through it. Now you've heard the explanation, you understand how to use it, read it, consolidate your knowledge, and the most important thing, practice the techniques. There's no use having it in here if you're not using it in court, okay? Get rid of all your bad habits, learn all these good habits, okay? Right, I'll talk to you tomorrow. Betty, that's the end of today's session, right?
Yes, Judge. We can answer the questions tomorrow.
Are there more questions?
There's more questions, but they are still coming in, so we can answer them
Oh,
tomorrow.
answer them tomorrow. Well, there's a question here. Would you add that witness statements to your discovery document? Well, that's an interesting topic, that. I'll tell you what. In criminal cases, the state's witness statements have to be given to you as part of the disclosure in our constitutional democracy, where document privilege is outlawed. So you get the statements from them, but you're not obliged to give the prosecutor the accused statement, okay? So it doesn't work both ways. As for civil litigation, unless the trial proceeded after motion proceedings, you will not have witness statements. Now, what happened in other jurisdictions around the world, like England, Canada, some states in the US, Australia, India, what they've introduced into civil litigation is that the parties must swap witness statements. And it's brilliant. It works brilliantly because there's no BS anymore. You can see what the other side has got, and matters get settled all the time. So what happens there is that once pleading's closed, you've dealt with pretrial proceedings like discovery and so on. When all of that is done, expert summaries and so on, you have to swap witness statements. And by the way, in England, they've scrapped pleadings. Why? Because they are so technical, no one understands what the hell they mean anymore. So they're unhelpful to judges. They scrap pleadings. Now, the plaintiff files a statement of claim. You will see that in arbitration here in this country, which is accompanied by what is called a certificate or statement of truth. So they certify it's true. And the defendant files a statement of defense, which is also certified as a statement of truth. These statements are then swapped between the parties. Matters just get settled easy, because now you know what's going on. Myself and others, a few other people, have been recommending to the rules board that they should change the rules accordingly, that is, scrap pleadings and introduce swapping of witness statements. I promise you, you'll finish cases in a matter of months, not 3 years, not 6 years, in months. The Canadians finish any case in the High Court, from issue of pleadings to finality through judgment or settlement, 3 months. That's how long it takes them to finish a case in the High Court, 3 months. Yeah, we're still battling with 3 to 6 years. Anyway, but that's the state of affairs. So those of you who are still young, you have a lot to look forward to. And you'll see that all of these things will come true. So therefore, I'm saying practice it already. Okay, I'm going to stop now, Betty.
100%, Judge.
Right. All right. Have a good rest. I'll see you tomorrow.